presentation. Thank you.
Not on my side, but please don't
Can you
slow
hear
down
us?
on my. Yeah, please don't slow down on my behalf. I'll find a way of figuring it out or get the recording later.
Oh, okay, you had me just for a second there because we have the same initial and initials. So I thought I was leaving, but it was you that were leaving. So
That's correct.
Okay.
but you can, as long as you can hear it. Good afternoon, Sir Bongo. Okay, guys, let's start. If everyone can hear at least, and the others can see the presentation, I'm going to more truncated than last week. Last week it sort of carried on for too long, and Dr. Claudia also needs to present the part on tax and e-commerce. So this domain names and trademarks. I'll try to keep it to half an hour so that we can also cover the tax parts of so let's get started. So there are the learning unit, or what we would want you to know about this learning unit. You'll see that you have very or rather limited resources to consult for this part of the module, but it is quite intricate. So you need to please look at it in a bit of detail so that you understand the concept. And I'm not going to go through all the details of what you need to know for this learning unit. This is more or less to just give you an understanding and enough background for you to be comfortable with what you will be studying and reading. So let's get straight to it. We're looking at domain names and trademarks. Now, we're all familiar by now with domain names, but there's a very specific structure regarding domain names, and I don't think we understand it properly enough in order to make it our own if we need to do what we need to do for this module and the questions you might encounter in assignments or exams dealing with these legal aspects. Now, trademarks and domain names, well, in the past were called uncomfortable bedfellows. They're not the same, but they mirror a lot of similar functionalities and resembling each other in some sort of way, but they're not the same. And that's where the big problem lies with understanding the difference between a domain name and a trademark, because some of it's very similar, the functions that they both fulfill, but they're also terribly different in how they in actual fact operate. The domain can be seen as a sort of a telephone number. It's a locator. If you have a domain name, other people can locate you on the internet. So you can send messages. Messages can be sent to you. So you have a locator. In IT terms, that's called the Universal Resource Locator, or the URL of a website, for example. So it maps numerical addresses and that falls within the domain name system. Now, the domain name system is a quite complicated system, but if we look at it quite simply, it is a network of computers that are controlled from a singular source that runs down like a pyramid. And all of these, let's call them computers or networks, that run down the pyramid speak to each other, and they translate messages to each other, and that's how we manage to send emails, go to websites, and how the network operates. But the problem is that the domain name network is a virtual network, and that the trademarks regime deals with traditional, on-the-ground territorial trademarks or territorial. They only matter within a particular jurisdiction, although they are international, but trademarks are territorial in the sense that national legislation determines whether a trademark is registered or not, and whether trademarks rights may be enforced within a particular jurisdiction. So there we immediately see the sort of head-on collision between domain names and trademarks, because they fulfill similar functions, but their origin, their levels of protection, their process of registration are totally different. So I'm just going to try and sketch a little bit of a background to you. The internet history is very interesting. You'll see one or two of those pages are subscribed as learning material, although we'll never ask you in detail in an exam to relay for us to understand or comprehend internet, e-commerce, and then what we're discussing today. So where the slash came about is that, as I said, domain names are territorial, so you register a particular trademark within a particular national jurisdiction in Madrid conventions that are the international conventions that protect trademarks. And our local or domestic legislation, our Trademarks Act, to a large extent conforms to the Madrid and the Paris Convention. So if you infringe a trademark in South Africa and it's a registered trademark or even a common trademark, then you are protected in terms of both our national legislation, which is then compliant to the international treaties. But the domain name is something totally different. A domain name is registered on a first-come, first-served basis. So there's no investigation into whether a domain name can be considered to be a trademark or whether a domain name is infringing on a particular trademark, whether it be a well-known international mark or simply a registered domestic South African mark, for that matter. So you can see the imbalance between domain names and trademarks. And from an intellectual property law perspective, that is quite a big clash that in practical terms needs to be dealt with, because our lives for the past 20, 30 years have centered around the internet, and it's playing an integral role in commerce. So we need to protect trademarks on the internet. And domain names are the primary. Last week we spoke about trademarks as part of linking and framing and websites and all of that, which is also critical. But domain names are the primary form. Trademarks are infringed on the internet. So firstly, just the domain name system, as we all know, and this is, well, not critically important for you to know, but to understand, the concepts of it will make it a lot easier to understand how the system operates and why certain aspects of our law in terms of the system is important. So if you look at the normal domain name, let's say mcdonalds.com, it seems quite simple enough, but the internet and how it's structured, I've spoken earlier about the pyramid and how it's structured, because everything relates back to main servers. That's called the A-root servers, and those servers then relate, that's a technical internet term, to other servers which translate the messages to other computers, and that's in essence how it's quite complicated. I also don't understand it, but that's how in essence it operates. So when the internet started, and you'll see a little history there within your study material, we had American international non-profit organizations. It actually started with the American Defense Department, and as it grew as a form of communication, it was then in the late 90s with control handed over by the United States government in terms of a memorandum of understanding with the Internet Corporation for Assigned Names and Numbers, and they fulfill certain critical functions in terms of the internet. And one of those functions, in essence, is protecting the rights within the network of people using the network, which includes trademarks. So protecting trademarks stands very distinct responsibilities. So the manner in which we then view the importance of how trademarks are protected within the domain name system, or the DNS as it's called, is the fact that trademarks are regularly infringed, and trademarks have been infringed from the start of the commercialization of the internet. Now, firstly, quite early in the evolution of the internet, we got very limited, what we call top-level domains. And that's an important distinction to make in understanding also what we are doing here. Is a top-level domain is the last part of an internet of a domain name. It's the .com or the .net or the .org. They were originally, without going into too much detail about that now, only 7 top-level domains, which were the .coms, the .orgs, .nos, and then they were called GTLDs and the CCTLDs, which are the country code top-level domains, which include our own .za domain. But within all of these domains, as I mentioned earlier, domain names could be registered on a first served basis. We had huge trademark infringement when the internet started exploding and becoming a commercial reality. So there we saw a lot of trademarks, well-known marks, being registered as domain names. And something needed to be done about all these international treaties. Has always been to protect trademarks, intellectual property, even though it's in a different country. It's a worldwide phenomena that we need to protect intellectual property as far as possible for the signatories of those international agreements, which is important for every individual jurisdiction. It created the cyber is just very simply registration of a registered or a trademark as a domain name. As we get the UDRP from, and that is the Uniform Dispute Resolution Policy by ICANN, when ICANN took over control of the internet or management of the internet in collaboration with numerous international organizations, most importantly the World Intellectual Property Organization, or WIPO, which concluded a number of domain name processes, and in the process developed the Uniform Dispute Resolution policy. In terms of domain name disputes on an international level, is the network as the enforcement mechanism. And this is very important to understand, because one would say, how can a mere form of alternative dispute resolution and identity or alternative dispute resolution, how the internet operates. It operates in the form of a pyramid. We've got the A root on the top, which is very simply put, it's a network of computers that trickles down to other networks, but they all come back to the same place, and that place is controlled by ICANN. Now, may enforce the rules regarding the primary functions within how the internet operates, and therefore may then enforce the UDRP, or the Uniform Dispute Resolution Policy. So if you register internet registration agreement with
Eddie,
a particular
Professor Hutter, if I may, you're breaking up quite a lot. I initially thought it was my own network that, yeah. I just wanted to check in with the students. Have they been following you correct? Well, just want to check in with the students. I mean, I could follow you, but I just want to make sure that, you know, we utilize
if someone could just respond to that.
Could any of the students respond to that, please?
Hi, Prof. I wasn't able to hear as well. I thought it was just on my side.
Oh my goodness. Okay. I'm not sure what it is. It might be my connection. I'm not sure. How is it now? Better?
Yeah, it's actually far better now.
Okay. Okay.
Very
wonderful. Okay, let me just think what I said last. Oh yes, it's regarding the network and how that works and how that enables the resolution of a domain name dispute. The essence of it is that ICANN, which controls the internet, basically provides authorization to certain registrars which need to comply with certain rules in order to be able, they play an intricate role in the management of domain names. And the registrars, the registries then appoint registrars which handle the registration of domain names in a particular jurisdiction. Now, if you register a domain name, then you are obliged to sign a contract. And part of that contract is that you will submit to an alternative dispute resolution procedure if there's a domain name dispute in order to have that dispute resolved. So, and that the remedy, it's a mandatory procedure. So the essence of that is that you don't have a choice in committing to the procedure. So if someone logs a dispute and it follows the process of the Uniform Dispute Resolution Policy, the remedy is immediate. It is affected by the registry. So if someone says your domain name is an abusive registration and an arbitrator found or an adjudicator found that it's abusive, your name may be transferred or cancelled without you having any say in it. So that's what makes the system so effective. So let's move on. I think that's enough background for now. The UDRP then is the international dispute resolution system employed by ICANN for the resolution of domain name disputes within the top-level domains, the .coms, the .orgs, the .nets, and many other country code top-level domains. But South Africa has chosen to do our own dispute resolution system that, of course, is under the auspices of ICANN as well. That is very similar to the UDRP, but a country code top-level domain like .za may choose to have a separate dispute resolution system. The .uk, for example, United Kingdom also has its own. but there are not very many of them. But that is all conducted under the auspices of ICANN. So you need to get special permission. And you need to apply and all of that. But the point is that domain name disputes may be resolved by way of the UDRP or in terms of our own dispute resolution regulations. And you'll see that quite a big part of this learning unit is the explanation of the dispute resolution procedures. We discuss within the prescribed study material, the Uniform Dispute Resolution Policy, and then also the regulations in terms of the South African regulations for the resolution of domain name disputes within the .za domain. Now, just to highlight a few things to look out for there. A domain name dispute is basically based on three very important principles, and that is, if you have a look at the UDRP or the Uniform Dispute Resolution Policy or the regulations, you'll see they are very similar, but there are also very important differences. But the most important aspects of those to focus on, because we may ask you questions dealing with that, is what you need to prove in order, or what you need to consider in order to determine whether a particular domain name was registered and used in bad faith. So please have a careful look at those. Firstly, in essence, the complainant, the person that institutes the dispute, needs to have rights on the domain name, whether it be registered trademark rights or common law rights. You'll notice that if you look at our South African regulations, the definition of rights is a lot broader than the definition of rights within the UDRP, but the definition of rights includes intellectual property rights, commercial rights, cultural rights, linguistic rights, religious rights, personal rights. So the personal rights include rights in terms of a contract, for example. And then the other very important principle you need to consider is the second one, is whether the domain name is similar or confusingly similar to the registered domain name. Now there, I'm just going to point out a few highlights. It's discussed quite in detail in your study material and with a few examples that'll make these aspects clear to you. But just adding a generic term to a registered trademark, for example, like MTN is a registered trademark, it's a well-known trademark. Just adding the name services to that trademark will then be, for that particular part of the domain name, be regarded as being confusingly similar. And then we also get what we call typo squatting, where only a few letters of a specific domain name are maybe changed. Like instead of Standard Bank, we'll say Standard Banks, and we register that name, and you know, that would be deemed to be a confusingly similar name. And then I need to finish up again. What you need to look out for is that there are certain circumstances that indicate that a domain name may be an abusive registration or a bad faith registration. for example, that the name was registered or required primarily for the purpose of selling, renting, or otherwise transferring the domain name to the trademark holder. That's the classic cyber squatting example. Or that the domain name was registered in order to prevent the owner of the trademark or the service mark from reflecting the domain name in a corresponding name. Or that the domain name was registered primarily for the purpose of disrupting the business of the competitor. So those are all probable indications of whether a domain name registration may be an abusive or bad faith registration. And then we also get a number of listed circumstances, and keep in mind we get this in both the UDRP and within our regulations. They differ not substantially, they're essentially the same, but they do differ, so please keep an eye on that. And then the respondent or the person owning the domain name can then also indicate with a certain number of factors that the domain name is not an abusive registration, and that is, for instance, that the domain name demonstrable preparations to use the domain name in connection with a bona fide offering of goods, that the domain name holder has been commonly known by that name, or that the domain name holder is making legitimate non-commercial or fair use of that domain name. And in that category, we'll get the gripe site domain names as well as the domain names which then elevate the domain name of the or the praised domain name, so to speak. And then we also get the split mark domain name disputes, in which both the parties have a legitimate interest. So unfortunately, time has caught up with me again, I see. So see that there just one more thing. I hope that was very fast again and we didn't go into enough detail, but you'll see when you read the cases we prescribe, as well as your textbook that is prescribed, you'll get a very good idea of what I've spoken about. You'll see there are two resources listed there. That is the one article regarding reverse domain name hijacking. That is basically, in very short terms, where a trademark holder then institutes a dispute against a respondent or holder of a domain name, which is in essence not legitimate in terms of what the goal is for doing so. It's, for instance, when a big company with a very prominent name try to monopolize that name so that no other entity, person, individual, company may use any of that. Just as an example, let's say my friend registers the name of an auction company and he calls it Bid Easy, and now the very well-known company Bidvest comes and says, or institutes a dispute and says, but listen, we've got sole power over the word bid. So you're cyber squatting. That's just a classic example of reverse domain name hijacking. You can have a look at that in the regulations, and then you'll also see we prescribe the article regarding the new .africa top level domain. ICANN in 2008 started the new GTLD program, and in terms of that, 2,000 new GTLDs were registered, including geographic names like .Africa. So you'll see on the internet a lot of different company names as top-level domains, or a lot of different terminology as top-level domains, which will mostly also be resolved in terms of the UDRP. And then let me stop there before I take too much time of, if I give Dr. Claudia too little time to do her presentation properly. So thank you very much. I'll stop there for now. Dr. Claudia, you still there?
Yes, I am. Can I ask that you unshare?
Okay.
Thanks.
Sure.
Good afternoon. I'm just waiting for the slides to upload. Can you see them? Class?
Yes, okay, it disappeared. It came and it disappeared.
Okay, okay. All right.
Yes, I can
Okay.
see it again. Sorry.
There we go.
Yes, yes.
All right.
Yes.
Okay, yeah, thank you very much. Good afternoon again. I also have system issues. I hope I'll be able to deliver this, my presentation before the system cuts me off. Let me just switch off, close my emails quickly so that we don't get any disturbances. Yes. Now you are seeing my business. So this is the last learning unit on taxation. The overview in tutorial letter 102, you will find it's that we will deal with the implications of e-commerce on taxation and some international initiatives that have been taken to implement new tax rules that govern income tax on the internet. Will also be explored, and the challenges posed by e-commerce on the jurisdiction to tax income. The residence and the source-based taxation, and also the administrative and enforcement of tax rules. So what I'm going to do, because we don't have time, I'll just focus on maybe one or two things. Everything is in the material that we have posted for you online, and all the articles are there. So after learning this unit, you should be able then to explain the impact of e-commerce on income tax in both domestic and law. You should be able to disclose and explain impact of e-commerce on the source basis of taxation that is applied in respect of non-residents. And lastly, the most important concept or issue that we'll be covering is the issue of permanent establishment. So moving along, your prescribed material for this is the Kudusa article on tax and e-commerce, where is the source, and Oguto and Cladi, e-commerce, a critique on determination of permanent establishment, and then again the green paper on electronic commerce. Only focus on specific pages. So that chapter on e-commerce is chapter 4 in the green paper. What you need to focus on there is just page, I think 36 and 37, only where it speaks of source and nothing more and nothing less. So to the introduction quickly, again, we know before a country can levy taxes on income, there needs to be a connection or tax nexus between itself and that income. And examples then will be your resident nexus or your source nexus. So you can go to the Kudusa article at pages 330 to 335. You will find explanation or a discussion on source and how e-commerce applies there. Then we have issues with multinational companies being incorporated, having incorporated subsidiary companies in other jurisdictions, and those jurisdictions are considered a separate legal entity that is liable for for tax purposes. If, however, a business is not considered a resident of a jurisdiction in which it is situated, that jurisdiction may not levy taxes on its income, unless the business profits of the entity can be attributed to a permanent establishment located in that jurisdiction. Therefore, the significance of PE, or permanent establishment, it gives the country in which the business entity is situated, the source country, which will be referred to as the source country, the right to tax its income, notwithstanding the fact that the PE has no separate legal existence. Everything that I have on the slides is drawn from the two articles, Oguto and Ntladi article. From the green paper itself, what you need to draw there, it will give you in chapter 4 an overview of what that chapter is about. As I said earlier on, only focus on the source based and what other challenges in South Africa in that regard when it comes to e-commerce. So just without wasting any time, I'm just going to go straight into permanent establishment, or PE, and its background. Again, you'll get that information from the Ntladi article and the Oguto article. It's stated there on page 76 that there are two main rationales for a PE. The first one is that there must be presence of a PE, evidence that a foreign company conducted significant business within the source country. And the second one, the PE permitted source countries to share tax revenues from profits created by commercial opportunities presented by the market. And moving along to the international aspects of it, if you also look, you also see in the green paper itself that it refers to the international tax concepts, and then we'll refer to the OECD model convention. The green paper also refers to that. So when we're talking about PE, then the issue that comes to play here, on article that students need to refer to, is Article 5 of the convention, the OECD model convention, which defines a PE as a fixed place of business through which the business of an enterprise is wholly or partly carried on. The three elements, therefore, from that definition are: 1, the place of business; 2, place must be fixed; and 3, the business of the enterprise must be carried on through this fixed place of business. The elements, therefore, of a PE are that it will only exist if the enterprise has physical presence in a source state. Article 5.2 of the OECD Model Convention notes the following as a place of business: it's a place of management, there is a branch there, or an office, or a factory, or a workshop. The size of the premises and the equipment required to constitute a place of business depends on the nature of the business, and it is irrelevant whether the premises are rented or owned. Moving along with the elements of a PE, a place of business must also be fixed. There are 2 requirements when it comes to that. Number 1, there must be a specific geographical spot or location, what is referred to as a location test, which requires a link between the place of business and specific geographical point. The test is that the business should be commercially and geographically consist of a coherent whole, and a certain degree of permanence at each geographical spot, or the duration test, a certain degree of permanence is required in order for a PE to exist. You can also go to that article and find out more about that. And again, looking at the elements, one of the elements being through which business is carried on. Here we're looking at business where a business of the enterprise is to be carried on wholly or partly through a fixed place of business. And the phrase carried on through implies that the business activities are carried on at a particular location that is at the disposal of the enterprise for that purpose. And this does not mean that a PE will only exist if the individuals are present. While presence of individuals may be required for the setting of a PE, their ongoing presence is not required. And this will also look at the fully automated equipment operated and maintained by an enterprise in the host country. It also consists of a PE. Now, the exclusions, as outlined in Article 5.4a to F of the OECD Model Convention, these are the things that are excluded from the PE definition that we have just outlined earlier. These will be the common features, which will include activities of a general preparatory or auxiliary nature. A decisive criteria is whether or not the activity of a fixed place of business in itself forms an essential and significant part of the enterprise as a whole. So here a PE will also be deemed to exist where a dependent agent has authority to conclude contracts on behalf of the enterprise and habitually exercises this authority in a source country. So you'll see some of these concepts coming out now when we talk about, when we look at the impact of e-commerce on the whole thing, whether it be the independent agent or, you know, that fixed place of business. Issues that will be coming out on e-commerce is how then does e-commerce impact on that. So looking at the challenges, therefore, that are determining the existence of a fixed place of business when it comes to those challenges, we look at online retailers that cannot accomplish much via a website that transfers transaction costs to customers. Then you look at internet websites that allows enterprises to interact directly with consumers. Again, multinational companies centralize many of their operations, including sales, advertising, marketing, etc. And the websites are performing administrative functions such as communicating with the head office, or, you know, when a sale is being registered. So if you look at the fixed place of business earlier on, these are the challenges now that are challenging the whole spectrum of that, of a fixed place of business. Then we look at the challenges to a dependent agent. Here we look at companies which usually employ dependent agents in source countries to perform certain functions such as finalizing complex contracts or exploring new business opportunities. And then the issue of intermediaries such as brokers, distributors are also greatly reduced as internet technologies can fully automate the order billing, filling, contract negotiations and payment. So cut the middleman. Again, the responses then, therefore, of the OECD to all these challenges that were highlighted above is that you have issues. Can a website then constitute a PE? Can a server constitute a PE? And again, can an ISP constitute a PE? Looking at what a website is, starting the first class of the class, we did highlights of what different terms mean, but in this article you also find indication of software and electronic data stored on server that allows an enterprise to interact directly with its customers. So those are that's the definition that the authors have put forward. But remember, depending on the article or the resources that you're using, you might come out with a different definition. All we are asking for is that you provide sources for everything that you have extracted from different prescribed material. It's a virtual office. Find that in footnote 65 in the same article, but that article 5 of the OECD paragraph 42.2 states that an internet website is a combination of a software and electronic data, which does not in itself constitute tangible property. There's a place on that can constitute business, as there is no facility such as a premises or, in certain instances, machinery or equipment as far as the software and data constituting that website is concerned. If you refer back to Article 5 that we have listed before, you will note that some of the concepts here, are identified in that article. And the next question then is whether then a website can constitute a PE, looking at those provisions in that article. Second one is, can a server constitute a PE? And here, a server is an automated equipment on which an internet website is stored and through which the website is accessible. Article 5, paragraph 42.2 of the OECD Model Convention states that location may constitute a fixed place of business of the enterprise that operates that server, and that the server used regularly for enterprise business may constitute a PE if it is at the disposal of the enterprise for that purpose. Another question is, can an ISP constitute a dependent agent? We saw earlier on that you will need those dependent agents to run some things for, the company itself, the host company. So here the question then is, can it then constitute a dependent agent? And an ISP is a company that supplies the internet to users for a monthly subscription. Again, refer back to the slides, the first class, I think, virtual class that we had. It has those definitions, or the second one. Then an ISP provides the services of hosting enterprise websites on their own servers. Article 5, then paragraph 42.10 of the OECD Model Convention states that an ISP does not constitute a dependent agent of the enterprise to which the website belongs, because it does not normally have the authority to conclude contracts in the name of that enterprise. So an ISP is normally, it will act independently and in the ordinary course of their business, which entails hosting websites of many different enterprises. The website through which an enterprise carries on its business cannot be considered an ISP, a dependent agent, since it is not a person as defined in the convention. Again, remember, e-commerce challenges these traditional issues, or what we have come to know as, whether it's a person will be, described as, we see those concepts are now taking shape, they're changing because of the space we all operate in. You'll note again in that article, the Ogutu and Tladi article, that there are other issues that the authors are grappling with, but these ones, you can just go and just touch upon and look at those. What is it that they are discussing? For instance, difficulties locating said servers, the possibilities of increased tax avoidance schemes, and administrative challenges. You also note in the green paper that there are also administrative challenges that were highlighted. I think towards page 45, 46, 47, you'll find those challenges. Other issues that the authors are looking at is the position in other countries, whether it's the US or the country that is under discussion. You'll also find in the green paper, we also take the US is also there, the position in the US, then a source basis of taxation or e-commerce context. You can look at the Gutusa article or the Gutu and Tladi article, the views on how to tax e-commerce effectively. You can also check pages 95 to 92 and 95 of Tladi and Ogutu and Tladi and withholding tax approaches. You can also look at those articles, those page references. I think, yeah, what I had was this, and the reason why we don't go into detail, as law students, we have been told earlier on when we get into to study law that legislation is our main source, and then some of the articles or the extra from books, those are secondary sources. So when we look at these articles, we get what the authors are saying about a particular principle that students might have studied. And I know that taxation, like IP, like some of the issues that we had touched upon in this module, elective modules, and therefore we don't get into detail into that. But if you look at the go back articles, you can go through the discussion whether on source, what is source, the laws in South Africa that regulate source-based tax and all those. But what is important, especially going into the examination for students, is exactly the concept of permanent establishment that we had just touched upon. So in this, for that specifically, you need to understand that what is a permanent establishment. Students need to discuss what that is. And even if you go to the model convention itself, you also need to, don't forget to reference sources. So you need to find out from you if you understood how this concept works. You need to know what it is, its elements, should you be asked, because these elements also touch upon, they are being challenged by how e-commerce comes in, it challenges all these, the existence of that. Then you need to also go to, when it means to be a place of business, but most importantly, because these are it's a commentary on Article 5. What we also need from you as students is to know how e-commerce challenges this concept of PE. And therefore you need to give us the challenges, to dependent agents, to the fixed place of business. So you need to connect these things when you are doing when you're answering this question. Can a website constitute a PE? Tell us what a website is and what the OECD says. Again, with the server, can it constitute a PE? You need to know what that is and also tell us what the OECD says. And again, an ISP constitute dependent agent. We also need to know what a dependent agent is and how the OECD does that. And some of the things you can also get from the Kutusa article. I think she touches upon 2 pages on that, on which we also use. We also encourage students because I think previous years we had also articles or extracts from books in this regard, although they are not prescribed this time. If students go and access other sources, please make sure that you prioritize what we have given you already so that we can assess you, but you are more than welcome also to use those sources. Just make sure that you refer to them in a proper manner as per university guidelines, and that you acknowledge where you have where you got those sources. I think I'll stop here, and for me, for the taxation part, the rest of the stuff you can read for yourself to find out how things work. I see now, I think it's Kenya now, they are talking about digital, taxing digital businesses, which is interesting. That is one of the issues that I think the green paper has had highlighted as well, issues around taxing, business, how do you levy those things? So there are interesting things coming out, and you will note that even in our material, some of the things we have covered because this area changes rapidly. Some of the things are not covered in the module itself, but we have given you a background or a foundation, of what needs to be done, and the rest you can do on your own. So that is my side of things. I hope perhaps maybe students can just, if they have questions, concerns, whatever, then we can move with that. But for me, taxation, PE, make sure you know it in and out, and it's going to be a 25-mark question. Already I've given you a scope. Thank you.
Thank you, Dr. Clary and Professor Ritter. We have there was some bits and pieces, but I think the recording, once everybody can re-listen to things, it might be a bit clearer. And of course, I will post the PowerPoint. I've already posted the PowerPoint from Dr. Sebo Clary in the files on the classroom, and I'll post the recording for everyone. If you have very specific questions after having gone over the work, I'm sure that we'd be happy to answer any questions. However, in this session itself, you have a few minutes. If you have any questions, show of hands would be great. Thank you. Charisse?
Hi, thank you lecturers for all the lectures. They've really been helpful. My question is regarding the exams actually. Is it possible for you all to give us a format as to how many questions or something along that line?
Okay, thanks, Charisse, for the question. I'm thinking next week we'll have an session, but the format is exactly the same as your assignments, except that we'll have 4 questions, 25 marks each, and we will choose from the learning units which questions. Should we do this perhaps next week? Let's just be on the go into the exams and prepare you for the exams. Then we'll get into detail regarding that, if you don't mind. But it will be 100%. It will be 100 marks, 25 mark question each, and the format will be exactly the same as your assignments, like the questions that you are getting on an assignment, whether it's an essay question or just a scenario type question, and then you have to answer a few questions on that. Perhaps also let me take this opportunity, Mr. Gama, to tell the students that we will start marking, and we should be able to, I hope you should be able to get results latest next week Friday. They will be revealed that you have ample to prepare for the exams and to know what is expected. Thanks.
Charisse, is that a lingering hand or a new hand?
I think it's a lingering one.
Sorry, it was a lingering one. My computer froze for a second.
No, that's fine. you know, I think that's brilliant that we'll have a final lecture just to tie everything together. Any questions from the other students on what was discussed today? I don't see any hands. I think I just wanted to say thank you to Professor Herta and to Dr. Claudi for the lecture. I enjoyed listening to it as much as everyone else, which is why I was disturbed when I couldn't hear every single word. Yeah, I'll be posting correctly the notice for next week's class. Thank you.
Thanks, Mr. Gama. I think students can also refer to tutorial letter 102. It has the preparation for exams at the end, so that you get an outline of what's expected. Thanks, and bye.
Thank you very much, everyone, for attending. Thank you, Mr. Gama and Dr. Claudi. Much appreciated.
Thank you and have a great day. I'm going to stop the recording now.
Thanks.